Hello, everyone, and welcome to the Shadowproof YouTube channel. I'm Kevin Gosztola. I'm the managing editor for Shadowproof. I'm also the curator of the Dissenter newsletter. We're here to cover the breaking news coming out of New York City from the Southern District of New York, where Joshua Schulte, who is the former CIA programmer, was convicted by a jury, a federal jury, deliberated for nearly 3 entire days. And then what they decided was that Joshua Schulte is guilty of leaking the Vault 7 materials, these CIA hacking materials, to WikiLeaks. And despite the fact that, and they probably didn't know this, I know that they didn't know this, but even though there was a mistrial in a earlier trial back in March 2020, that in this second trial, the prosecutors had convinced them, with basically the same evidence, that in fact Schulte was responsible for the leak. So to talk about this, break it down, I have friend, colleague, John Kiriakou, who is a former CIA officer and whistleblower. And for those of you who do not know, John, he is also someone who was targeted in an Espionage Act prosecution and then did some prison time for offenses that stemmed from that Espionage Act prosecution. So welcome, John.
Thanks, Kevin. Good to be with you.
And so let's get right onto it. Give me your raw reaction to seeing that Joshua Schulte was convicted by this jury, and especially when considering how long it took for them to arrive at their verdict.
The longer that the jury was out, the more I convinced myself that it was either going to be a hung jury or that he was going to win and to be acquitted on at least some of these charges. I have to say that I'm shocked at the outcome of this case. Like you, I had been reading reporting from Inner City Press and the transcripts when they were being posted, and it was so confusing. I honestly didn't see how any jury would be able to say definitively, oh, well, that information, that testimony has convinced me that he's guilty. It didn't convince me of anything. It was so difficult to follow that even after reading every day of the hearings of the trial, I was convinced that it was too complicated, too esoteric in many cases to convict him. And then, like you say, it was 3+ days. Because it dragged on as long as it did, I was sure it was going to turn out well for him, and it didn't.
And just to be clear, for those who are coming and might have some basic knowledge of the case, there are other criminal charges pending against Joshua Schulte that come from the FBI raid. He faces child pornography charges that I was told by actually Matthew Russell Lee of Inner City Press stems from the fact that he is a libertarian who hosted a server in which he would allow anything to be kept on it. And he was not controlling the content. And so it looks like the FBI might be able to nail him for having this material. I don't know. But again, child pornography is always serious. I don't want to diminish it, but it is separate from our conversation about these charges, and it will be separate. And everyone who comes after Joshua Schulte, like the pending case against Julian Assange, it'll only be about whether or not Joshua was actually involved in and responsible for this leak. So we'll stay focused on that for our conversation, and I'll stay away from judging the character of Joshua Schulte. But it does seem like the evidence that was presented, people may have seen the New Yorker magazine, the New York magazine article, or I think it was in the New Yorker. Yeah, the New Yorker magazine article that covered him and gave us extremely intense details about what it was like working in this cyber intelligence center and how he was at war with his colleagues. And he even filed a complaint in a district court. And he was known as a person who would go nuclear and not settle disputes within the CIA. He would not follow processes to resolve his issues. He would take dramatic action in order to get the results he desired. which leads me to believe that he was someone who was flagged as a disgruntled employee. And so what happens at the CIA among supervisors who know about disgruntled employees?
Well, it's changed over the years. Time was where if you were a disgruntled employee, they would do what they could to make you happy. Perhaps that was a job change. Perhaps it was a career change. Now they'll profile you. They'll use algorithms to try to predict which employees are going to eventually become disgruntled. And now they'll force you to go to mental health care. They'll assign you to a psychiatrist. There's a mental hospital here in Northern Virginia that has a contract with the CIA, and they'll send you there for weeks or months to try to get you straightened out. But it's different now. Really, since the Chelsea Manning revelations to WikiLeaks, they're much more serious about trying to head this off before it becomes a problem for them, a security problem. One of the things about Joshua Schulte is, I just want to reiterate really what you said. He was extraordinarily difficult to work with. He didn't have any friends in the office. He didn't like or respect his supervisors, and they didn't like or respect him. But there were also reports that he was autistic, which would not surprise me one iota. You know, guys, people, whether they're men or women, in that job where you are a hacker, an engineer, somebody who is trying to protect the country by attacking the systems of other countries, that kind of a job sort of attracts people who like to work by themselves, people who are quirky, people who might be on the spectrum. And so, you know, going by the way his coworkers have described him and some of the testimony that we heard in the case leads me to believe that he's probably on the spectrum. They didn't know how to deal with that in his position, and it just didn't work out well for anybody.
Yeah. There's a little bit of static on your end. I don't know if that's coming from your phone moving. I just thought I'd let you know. I know there's a limit. Where John is graciously talking to us from an airport before he has to catch a plane, and I'm grateful for him to give us just a little bit of time.
Happy to do it.
But yeah, we'll just go through it, and I can still hear you and make out what you're saying. So I think it's still worth it. Let me read you. Okay. So one of the things that people have to know is I think the instructions, and when you're following that, you were saying this already, is when you think of what you're being asked to determine whether Josh Schulte is guilty of this leak. You know, first and foremost, we need to state clearly that they never showed the jury any forensic evidence that he had transmitted the information to WikiLeaks, which is different from some of these other cases, like the very popular one of Chelsea Manning being, you know, giving the information to WikiLeaks. They can see the transfers. Those are all there on the military computers. Now, what they claim is that Joshua Schulte is so smart. He knows encryption. He knows how to cover his tracks. He wiped things clean. And then what becomes difficult is in trying to follow the cross-examination of Josh Schulte, he's trying to, in a very technical manner, present to the jury, you know, how the evidence they've claimed of him wiping his tracks isn't actually wiping his tracks. Because you had to have a very technical knowledge of computing and encryption technology and all sorts of tools in order to understand what is being communicated. So I think that's just one point to introduce there when you're like, how could the jury not follow this? He clearly demonstrated that he didn't leak the material by saying there's no forensic evidence. But then the government's able to just come back and say, well, he's a smart guy. He can erase everything that he's doing. And then that washes away. They even said that the lack of evidence is not evidence of innocence. That was their statement.
Yes.
So then the other thing I want to say is you get an instruction on the Espionage Act offense. And I want to read this to you, John, just because I would like you to put yourself in the shoes of somebody who is in the jury. And also the people who are watching this broadcast, you're in the position of the jury. You hear this and you have to figure out what this means and whether, in fact, Joshua Schulte is guilty of violating the Espionage Act. So they have something called national defense information. And here's what they were told about that. The government must prove that the material is closely held by the U.S. government. In determining whether material is closely held, you may consider whether the material at issue was already in the public domain. Information typically cannot qualify as NDI if it is already in the public domain. But where information is in the public domain, the fact that the information comes from the United States government or the fact that the United States government considers the information to be accurate or inaccurate may itself be NDI. Thus, where information has been made public by the U.S. government itself, it is not closely held and cannot be NDI. Similarly, where information has been made public by someone other than the United States government, and the United States government confirms that the information came from the United States government, it is not closely held and cannot be NDI. But the United States government's assessment of the reliability or unreliability of publicly available information, as opposed to the information itself, can itself be closely held information relating to the national defense. And I know your head's spinning, but I got to get through the rest of this. This is what it must have felt like to be on the jury. In such instances, it is the confirmation of the accuracy or inaccuracy of material in the public domain and not the public domain material itself that can qualify as information relating to the national defense. The distinction between a confirmation of information relating to the national defense already in the public domain that can be NDI and one that cannot depends on whether the confirmation itself could potentially harm the national security. I mean, like, wow, like what must you be feeling on that jury as you listen to this?
You know, when you get instructions like that, it must lead you to believe that it's that complicated because it's that sensitive. And if it's that sensitive, they would never have brought charges in the first place unless he were guilty. So because he must be guilty. That's the only conclusion that I can come to. You know, let me give you a real life example too. I write a lot of books. I like to write books. And I wrote one recently on surveillance. And I said, there's one passage 200 pages into this thing about some surveillance that the CIA did in Austria in the early 1970s. And the CIA blacked it out. They redacted it. And they said to me, your manuscript contains classified national defense information. You have to remove it from the manuscript. And I wrote back and I said, you know, I got this off your website, right? And so they went back and they looked and it was on their website. And then they took it down. And then they said, well, we took it down. It's national defense information. You have to delete it. So, you know, you can fight them over the course of a year or 2 or 5, or you can just black it out. Well, try going up against them in a court of law with your life hanging in the balance. And the assumption is that you're guilty, even though there's no evidence that you're guilty, because their contention is that you're so smart, so diabolical, that even they aren't able to catch you. So like you said, even though there's no evidence that he effected the transfer of the information, that in and of itself they use to maintain his guilt. It's crazy, just crazy.
And we even have counter evidence. We have evidence that he was against leaking. We have evidence he thought that Edward Snowden should be executed and he was a traitor.
Mm-hmm. Yes.
We have also he goes through all this about how, like, he you know, if they say that the transfer of material happened in exactly a year, they picked this like arbitrary date according to him of it's exactly 1 year before March, the date in March 2017 when WikiLeaks published, and that's the day because he was all by himself on that day and nobody was around and he wouldn't have been seen. But then, like, all this stuff is happening and he stays at the CIA. He doesn't leave. He doesn't have an exit strategy. So he's there till November 2016. And then he leaves because he's leaving on bad circumstances of being at odds with CIA supervisors. I mean, it doesn't really make a whole lot of sense. But what is important for us to consider, I do want to mention he represented himself, and I'd like to get your reaction to. I'd like to get your reaction to this of how Sabrina Shroff was his public defender, and I think they figured out this kind of loophole to the Espionage Act prosecutions of you can't make a public interest defense if you are on trial, but if you represent yourself, then throughout representing yourself and arguing your case, you can share your motive and express yourself and say why. Well, in this case, he didn't, so he claimed he didn't do it. But you can give your side of the argument of why you're not guilty.
Yes, yeah. I was disappointed when he decided to represent himself, because in the first trial, the one that ended in mistrial, I thought his attorneys, they were public defenders then as well, I thought they had done a marvelous job. One of the things that I've learned is, even though most public defenders are grossly overworked and underpaid, the ones that are involved in national security law, the ones that represent the likes of Tom Drake, for example, and Marty Gottesfeld, they do fantastic work. They're very bright. They're highly skilled in the ways of the federal system, and they know national security law. And so when he decided to represent himself, even though the public defenders remained on as legal advisors to him, I thought that was a strategic error.
Impossible. I'll note that when he did his closing argument, he was very confident that no matter what, this is reasonable doubt. And he went down the line, and he didn't think, the way he presented himself, maybe he thought there was a chance he could be found guilty, but the way he presented himself, there's not a chance in the world you're going to find me guilty during this trial.
And that's why I was optimistic, because he was so optimistic in his closing statement to the jury. I thought, well, he knows this better than I do. I mean, I was pessimistic through my entire situation, but he was so optimistic. I thought, if he's that confident, he knows something that I don't, and he's going to win this thing.
Yeah, or he's overplaying his hand. Yeah, and so let's talk about, before I let you go, and you've got to catch a flight. So before we conclude here, he's been held in special administrative measures, and he's still under it. Matthew Russell Lee did some exceptional work when it comes to open access to documents in this case. Recently, he got the civil complaint that Joshua Schulte filed and some documents related to it unsealed. This Judge Furman looked at it and said, well, I don't know why this is a sealed docket, so let's unseal it. Matthew Russell Lee of Inner City Press gets access to all the files. He gets the original SAMS order against Joshua Schulte that's part of this civil complaint, which I think might have been public, but there's other stuff in there where Joshua Schulte argues that Attorney General Jeff Sessions committed perjury when he was designating him for SAMS, because certain things did not happen during this alleged phone call that he's had. So it's also worth noting, we didn't talk about it, but it's worth noting that he was convicted of one charge that comes from attempting to leak information from prison.
Yes.
Over a cell phone, which would have been a contraband cell phone.
Right. I remember that.
And so he's in these SAMs. He is at MDC. Now he's in Brooklyn. He's not at the condemned in disrepair MCC New York anymore. That's been shut down. So he's in SAMs. I'll put it to you in two parts. What do you think about the conditions that he'll continue to be confined in? And then what do you think this says about Julian Assange's case? WikiLeaks founder Julian Assange's case. And I have to insert here, the questions and all the issues that we've heard raised in the context of his extradition case about SAMS. And obviously the U.S. government has given us their assurances, which are hard to take at face value, that he's not going to be put in special administrative measures. But if they believe Julian Assange is going to still leak, this is what can be done to somebody.
Well, I think the most important point here is that it's not up to the prosecution. It's not up to the Justice Department as a department to decide who is assigned to a SAM and who is not. It's the sole discretion of the Bureau of Prisons. And the Bureau of Prisons hasn't entered into any agreement with the British courts or the British government to not put Julian in a SAM. Now, we've got a precedent that was set with Daniel Hale, where the judge in the Eastern District of Virginia recommended in quotes that Daniel be sent to a low security prison in Butner, North Carolina, to receive treatment for his post-traumatic stress disorder. The Bureau of Prisons doesn't care what judges recommend, and they send him not just to a regular prison, they send him to the Supermax in Marion, Illinois. And
it's a communication management unit.
Yes, a communications management unit, right. With special administrative measures, it's even more harsh than the communications management units, in that the CMU is meant to prevent you from communicating with people on the outside, whether it's journalists or friends of yours or somebody that you may be passing secret information to, or terrorist related information, whatever. These people are supposed to be trained to spot efforts or attempts to get information out of the prison. The SAM is even more harsh. It combines all of that with solitary confinement, with penitentiary level security, 23 hours a day plus of no human contact. It's, most people who go through it say that they would rather be dead than to continue living like that. And so, when every time I hear the Justice Department say, we've assured the British government, blah, 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 those words mean nothing, because it's the BOP that makes that decision. And the BOP hasn't promised anybody anything.
Well, the CIA can come in and maybe this same way they might have advised the BOP that, he was not in the CIA, but someone in the CIA or any other national security agency could have advised the Justice Department to put Daniel Hale in a CMU.
Absolutely.
And that's the way it works with Sam, someone in the CIA that, by the way, has such a deep-seated hatred for Assange and what he did to them. I mean, publishing those Vault 7 materials is about as big of a punch. It's like a right hook to the jaw.
Didn't Pompeo call it a digital Pearl Harbor?
That's the way the agency has treated it. Exaggerating and saying that it was that bad but it was an embarrassment. According to the Yahoo News report, that's when they started developing the secret war plans for going after and kidnapping or killing Julian Assange, because Pompeo was so embarrassed, and they thought they were unique. They thought, this doesn't happen to us. It happened to the State Department with the cables. It happened to the Pentagon with the military reports, but we're going to be fine. We take care of our information. Our networks are completely secured. And then this took place. So, I mean, I guess I'll just end. I don't know if there's anything else you want to add before you run off.
Yeah, I'd like to add one thing if I could, Kev.
Yeah.
This case today was not just about Joshua Schulte.
Yeah.
As you mentioned, this case is about Ed Snowden and Julian Assange too. And the Justice Department likes to try to build on these cases. You'll notice that each sentence is harsher than the previous one. Okay, nobody's getting 30 months anymore or 36 months. They're getting years, and they're getting years in higher and higher security prisons. So I think that we need to be worried about Julian Assange. We need to do whatever we can to either help ensure that he is not extradited to the United States, which is obviously very tough at this point, or assure that, or not assure, but work to the end that he's acquitted.
Yeah, and there's a few things that really stand out as we wrap up here, which is very scant amount of evidence presented to
Yes,
convict. I mean,
very.
that's something Assange's lawyers have to be concerned about,
Mhm.
have to be
Agreed.
really worried about, and we don't know. The fact is that as I talk to you, I don't know definitively if Joshua Schulte didn't give the materials to
Right.
WikiLeaks.
I don't
I
know either,
don't. I
but that's
don't
called
know.
reasonable doubt.
Right, exactly. I don't know if I don't know if he didn't give
Right.
the materials. I don't know if somebody else did. There were other people with access to that network. But that to me is like that shows you, and this was also something that Jeffrey Sterling went through,
Mhm.
where he gets pinned with a leak that during his trial they have very thin circumstantial evidence
Mhm.
to pin on him, and they just pick him out. Why? Because he came after John Brennan with a racial discrimination lawsuit
Right.
a while ago.
Yes.
so,
Ridiculous.
so this is what it's like. And then I'll conclude with the note that there are some good people out there trying to modestly reform the Espionage Act
Mhm.
just so that people might have a public interest defense if they're accused of violating the law.
Yeah.
There is no political support for it, though.
No, there's
And
not, and we should
yeah,
we should note too that Representative Ilhan Omar had sponsored a bill to reform and to modernize and update the Espionage Act. Unfortunately, despite the fact that bill blew through committee with bipartisan support, it was killed last night in the House Rules Committee. And
yeah.
she said that she would sponsor it again in the next Congress. But we're going to have to assume that she's going to have to sponsor it as a junior member of a minority party, and
Yeah.
I wouldn't be hopeful really that it would go anywhere.
I mean, we really have only two people. It was Rashida Tlaib and Elon Omar who sponsored it. We've had Ron Wyden in the Senate who's been willing to consider
Yes.
reforming the Espionage Act, but his bill didn't propose a public interest defense. It
No.
was only to protect journalists.
Yep. That was it.
And so it's kind of bleak. And this is the state of play for everyone, and we have to call it like it is. But for those people who are angry, I say don't hesitate to tell people who are in power that you're really upset with them, that they don't take an interest in all of this. And I thank everyone for tuning in. I thank you, John.
Thank you, Kevin.
And I'll let you go. I'm going to do a wrap up here with my audience. But
Thank you. Good to see you.
catch your flight, safe travels, and we'll talk later.
Thank you,
Okay.
sir. Take care.
All right, everyone. That was John Kiriakou, former CIA officer and whistleblower. And if you don't know anything about his case, I encourage you to look up his letters from Loretto from when he was imprisoned. And you can look for some of the reporting over on shadowproof.com. We extensively covered his case when he was accused of violating the Espionage Act, and then he was convicted. He took a plea agreement around violating the Intelligence Identities Protection Act, which is a little bit different and more specific and less undefined when it comes to prosecutions. But yeah, so everyone, thank you for tuning in. I'm just going to put this up here and let everybody know who has been watching. This is my newsletter where I curate stories on whistleblowers. I have a story right now that is currently available for people to read. If you'd like to get more coverage, or if you'd like to help get the word out and let people know what happened, you can go here to the dissenter. Let me get my act together and actually do this correctly. So you can see there's the headline I have. Jury finds the former CIA programmer guilty of leaking CIA hacking materials to WikiLeaks. And if you go to thedissenter.org, you can find that story and you can share it and let people know what happened. It's got some details, some quotes from the court transcripts, and there isn't really any coverage out there. Not much coverage at all of this trial. It was a second trial. Again, there was a first trial. There was a trial before everything got shut down by the COVID pandemic and upended and delayed a whole bunch of cases. And then now he's had a second trial and a jury convicted him after there was a mistrial in the first, after the jury deadlocked and there was no conviction or acquittal in that first trial. And so with that, thank you. Again, if I still got a few people around here, hit that subscribe button and you'll know when we go live on this channel. You'll know when other videos are posted, and you'll receive the alerts. I'm sure you've heard this spiel from people who do this. All these content creators have to ask and hustle to get those followers, get those subscribers. And with that, thank you for following and listening and watching and supporting the independent journalism that I do on whistleblowers, truth tellers, national security, press freedom issues, etc. And I'll be back soon with some more reports on what's happening with these cases. Thank you.